Hello viewers, in this lesson we will learn about the banker's lien and set-off. Objectives: to learn about the meaning and modus operandi of banker's lien, to learn about the set-off of customers and bankers' claims. Viewers, now we will learn about meaning and definition of banker's lien. Banker's lien is the right of a banker in possession of goods, securities, or any other assets belonging to the debtor, that is the customer, to retain them until the debt is repaid, provided that there is no contract to the contrary. In Halsbury's Laws of England, the term lien is defined as a right in one man to retain that which is in his possession belonging to another until certain demands of the person in possession are satisfied. In its primary sense, it is given by law and not by contract. In Chalmers on bills of exchange, lien is defined as an implied pledge. A banker has, in the absence of an agreement to the contrary, a lien on all bills received from a customer in the ordinary course of banking business in respect of any balance that may be due from such customer. In Peggett's Laws of Banking, the banker's lien is defined as that apart from any specific security, the banker can look to his general lien as a protection against loss on loan or overdraft or other credit facility. The general lien of bankers is part of law merchant and judicially recognized as such. Chitty on contracts explained the lien as follows. The lien is applicable to negotiable instruments which are remitted to the banker from the customer for collection. When the collection has been made, the proceeds may be used by the banker in reduction of the customer's debit balance unless otherwise earmarked. The law on banker's lien. In India, Section 171 of the Indian Contract Act 1872 contains the provisions on banker's lien. Section 170 of the Indian Contract Act relates to particular lien, and Section 173 to 181 contain the general provisions for all kinds of lien exercised by different persons, whether it is a particular lien or a general lien. Thus, the banker's general lien confers upon the banker the right to retain securities in respect of the general balance due by the debtor to the customer. It is applicable to all the securities placed with the bank by the customer. A banker can liquidate a general balance due by the customer to the banker by selling those securities. Under Section 170 of the Indian Contract Act 1872, a bailee can exercise his right of particular lien, where the bailee has, in accordance with the purpose of the bailment, rendered any service involving the exercise of labor or skill in respect of the goods bailed, he has, in the absence of a contract to the contrary, a right to retain such goods until he receives due remuneration for the services he has rendered in respect of them. Mostly, this right is not available to the bankers. Section 171 of the Indian Contract Act contains the provisions on a general lien exercisable by bankers and others. The section reads as follows. Bankers, factors, wharfingers, attorneys of a high court and policy brokers may, in the absence of a contract to the contrary, retain as a security for a general balance of account any goods bailed to them, but no other persons have a right to retain as a security for such balance goods bailed to them unless there is an express contract to that effect. Under Section 172 of the Indian Contract Act, the terms used in pledge are defined. According to this provision, the bailment of goods as security for payment of a debt or performance of a promise is called pledge. The bailer is in this case called the paner. The bailee is called pani. The banker in this case is the pani and the customer is the paner. Under Section 173 of the Indian Contract Act, the pani may retain the goods pledged not only for payment of the debt or the performance of the promise, but for the interests of the debt and all necessary expenses incurred by him in respect of the possession or for the preservation of the goods pledged. Under Section 174 of the Indian Contract Act, the pani shall not, in the absence of a contract to that effect, retain the goods pledged for any debt or promise other than the debt or promise for which they are pledged, but such contract, in the absence of anything to the contrary, shall be presumed in regard to subsequent advances made by the pani. Under Section 175 of the Indian Contract Act, the pani is entitled to receive from the paner extraordinary expenses incurred by him for the preservation of the goods pledged. Under Section 176 of the Indian Contract Act, if the paner makes default in payment of the debt or performance at the stipulated time or the promise in respect of which the goods were pledged, the pani may bring a suit against the paner upon the debt or promise and retain the goods pledged as a collateral security, or he may sell the thing pledged on giving the paner reasonable notice of the sale. If the proceeds of such sale are less than the amount due in respect of the debt or promise, the paner is still liable to pay the balance. If the proceeds of the sale are greater than the amount so due, the pani shall pay over the surplus to the paner. Under Section 177 of the Indian Contract Act, if a time is stipulated for the payment of the debt or performance of the promise for which the pledge is made, and the paner makes default in payment of the debt or performance of the promise at the stipulated time, he may redeem the goods pledged at any subsequent time before the actual sale of them, but he must, in that case, pay in addition any expenses which have arisen from his default. Under Section 178 of the Indian Contract Act, where a mercantile agent is, with the consent of the owner, in possession of goods or the document of title to goods, any pledge made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same, provided that the pani acts in good faith and has not at the time of the pledge notice that the paner has not authority to pledge. As per the explanation in this section, the expressions mercantile agent and documents of title shall have the meanings assigned to them in the Indian Sale of Goods Act 1930. Under section 178A of the Indian Contract Act, when the pawner has obtained possession of the goods pledged by him under a contract voidable under section 19 or section 19A, but the contract has not been rescinded at the time of the pledge, the pawnee acquires a good title to the goods, provided he acts in good faith and without notice of the pawner's defect of title. Section 179 of the Indian Contract Act deals with pledge where pawner has only a limited interest. Under this provision, where a person pledges goods in which he has only a limited interest, the pledge is valid to the extent of that interest. Under section 180 of the Indian Contract Act, if a third person wrongfully deprives the bailee of the use of possession of the goods bailed or does them any injury, the bailee is entitled to use such remedies as the owner might have used in the like case if no bailment had been made, and either the bailer or the bailee may bring a suit against a third person for such deprivation or injury. Under section 181 of the Indian Contract Act, apportionment of relief or compensation obtained by such suits is narrated. According to this provision, whatever is obtained by way of relief or compensation in any such suit shall, as between the bailer and the bailee, be dealt with according to their respective interests. Features of banker's general lien. 1. A right of general lien is an implied pledge. A banker enjoys the privileges of a pledge in case of applying a general lien, and he can dispose of the securities after giving proper notice to the customer under section 176 of the Indian Contract Act. A banker's right of lien is viewed as more than a general lien, as the whole concept resembles a pledge, and it is usually called as implied pledge. In the 19th century, in Brandau versus Barnett, the House of Lords held that the bankers most undoubtedly have a general lien on all securities deposited with them as bankers by a customer, unless there be an express contract or circumstances that show an implied contract inconsistent with lien. In Burdick versus Civil, the apex English court held that the right of lien of a banker is regarded as an implied pledge because in case of negotiable instruments like coupons, bearer bonds, share warrants and other instruments kept into the custody of a banker as securities become liable to the lien, and the characteristics of a pledge enable the banker to sell the securities on default if a time is fixed for the repayment of the advances, or where no time is fixed, after request for repayment and reasonable notice of intention to sell were made, and thereby apply the proceeds in liquidation of the amount due to the bank. The right of sale extends to all properties and securities belonging to a customer in the hands of the banker, except title deeds of immobile property, which obviously cannot be sold, as in that case the banker has only a right to retain the deeds. The Indian courts followed the English court decision in many cases. Hence, The principle that a right of lien of a banker is an implied pledge is a global principle. 2. Right of lien can be exercised against any movables. This right can be exercised by the bankers on goods or other securities standing in the name of the debtor only. 3. Right of lien exercisable by the banker as provided under the Indian Contract Act. The relevant provisions are stated afore. Exceptions to the right of lien. This right cannot be exercised under the following circumstances. 1. Documents deposited for a particular purpose. In case of certain documents sent by a customer with specific instructions to utilize the proceeds for a particular purpose, like the bill of exchange, the banker cannot deviate from the instructions and exercise this right. 2. Safe custody deposits. In case of safe custody deposits, like valuable securities, documents, gold, silver, ornaments, etc., with the banker, the banker's status is that of a bailee or a trustee with the responsibility to ensure that they are safe from burglary, fire, and other exigencies. Hence, a contract inconsistent with the right of lien exists. In case of safe custody deposits, the banker cannot exercise this right of lien. 3. Right of general lien becoming a particular lien, where under certain circumstances a general lien becomes a particular lien, the right of general lien cannot be exercised. 4. Securities held in trust. When the securities are deposited with the banker as a trustee, the banker cannot exercise this right of general lien. 5. Securities negligently left with the banker. In case of any securities left with the banker negligently or by mistake by a customer, the banker cannot exercise the right of general lien. 6. Conflict with right of set-off. The monies deposited in the bank in the accounts of the customer and also the credit balance of the customer do not come under the category of goods and securities. Under such circumstances, the banker can exercise a right of set-off, but not a right of lien. 7. Contingent debt. Where the banker has a contingent debt, that is, no amount would be due on the date when the banker wants to exercise lien, the right of general lien cannot be exercised. 8. General lien is only to the extent of the liability of the customer. The Madras High Court in City Union Bank Limited versus Thangarajan held that the bank gets a general lien in respect of all securities of the customer, including negotiable instruments and the FDR, but only to the extent to which the customer is liable. If the banks fail to return the balance and the customer suffers a loss thereby, the bank will be liable to pay damages to the customer. In order to invoke a lien by the bank, there should exist mutuality between the bank and the customer. Retaining the customer's properties beyond his liability is unauthorized and would attract liability to the bank for damages. Viewers, we will now learn about the set-off of customers and bankers' claims. The right of set-off means the right of a debtor to take into account a debt owed to him by a creditor before the creditor would recover the amount due to him from the debtor. Under this right, the mutual claims of debtor and creditor are adjusted, and if any amount still remains to be paid by the debtor, he is liable for only that remainder. In case of a banker, like other debtors, this right is available to him. By exercising this right, the banker combines two accounts in the name of the same customer and adjusts the debit balance in one account with the credit balance in the other account. This right cannot be exercised unless there is an implied or express consent from the customer communicated to the bank. This right of set-off can be exercised subject to compliance with the following conditions. 1. The accounts of the customer must be in the same name. The accounts must lie in the name of same customer and in the same right. That means that the capacity of the account holder in both or all the accounts must be the same. The funds available in one account are held by him in the same right or capacity in which a debit balance stands in another account. The cardinal rule is that the funds belonging to somebody else but standing in the name of the account holder should not be made available to satisfy his personal debts. The best example is that of the case of joint account holders. 2. This right is exercisable in respect of debts due only. This right cannot be exercised in respect of debts due and not in respect of future or contingent debts. 3. Certainty of the amount of debt. The amount of debts from both the parties to each other must be certain. 4. Agreement to the contrary. The bankers can exercise this right of set-off only in case there is no agreement, whether express or implied, to the contrary. 5. Garnishee order. If a banker receives a garnishee order in respect of the funds relating to his customer, that is the bank's debtor, the bank has the right first to exercise its right of set-off and later on surrender only the remainder amount to the judgment creditor. Well, viewers, I hope you enjoyed this lesson. We will meet again. Thank you.